to have some fun today. You've done, I think Corby said 16 of these, is that right? So you know Title 7. You know you can't discriminate against employees. You know, you've heard this, you've been to dozens, probably more than that, of sexual discrimination, sexual harassment training courses. And so I don't want to bore you with the same legal talk. So today we're going to test your knowledge of Title 7. Now I've got some giveaways. I have 6, and so hopefully this is going to be a little bit fun for you. You kind of have the answers right in front of you in the handout, but I'll try to mix it up a little bit. Oh, now you're on. Before we do that, though, I do want to talk to you about a couple of current legal trends that we're seeing today in employment law. I'm going to stand behind the lectern because that's what I do it for. It just feels comfortable. So yeah, before we get to the test and the fun, let's just go over a couple of things that are happening in employment law, discrimination and Title 7 law lately. It's an older case, but Crawford v. Metropolitan Government of Nashville. This is an older case, but it's something that we're seeing a lot of recently. Essentially, this is a Supreme Court case, and as you know, as part of Title 7, there are anti-retaliation provisions. Anti-retaliation provisions meaning if someone complains of sexual harassment, you can't retaliate against them by firing them or demoting them or something like that. That's part of Title 7. This Supreme Court case said even when the employee has not filed a formal charge or a complaint against the employer, they're still protected by these anti-retaliation provisions. So think about that for a minute. Even though they haven't complained of sexual harassment, they're still protected against retaliation for complaining about sexual harassment. Let me explain. In this case, there was an employee who worked for a school district, and as part of an internal investigation, this employee was interviewed and asked about another employee who was being investigated, and she was asked if she had witnessed any inappropriate behavior. This coworker, in response to this interview that they were interviewing everyone, said that yes, this particular employee had previously made crude gestures and comments to her. Okay. The interview was over. Short time later, this employee that was interviewed as part of this wide investigation was fired for alleged embezzlement. And the employee then filed a lawsuit claiming that she was entitled to protection under the anti-retaliation provisions of Title 7, and because she mentioned in her interview that this certain employee had made crude gestures and comments to her. So the anti-retaliation provisions of Title 7 specifically, in order to discriminate against someone with this, the employee has to have opposed any unlawful practice or has made a charge or testified or assisted or participated in any manner in a protected investigation. So essentially, the first part is the opposition clause. And in granting this employee's motion, or granting the employer's motion for summary judgment, the lower court said that yes, they dismissed it. They said no, she didn't actively oppose this employee's crude behavior, and so she doesn't have a claim. Well, the Supreme Court reversed that and said you don't have to actively oppose discrimination in order to receive the protection of the anti-retaliation provisions of Title 7. You can simply mention it in an interview. So the take-home lesson is that you need to be extremely careful when interviewing employees. You need to train your investigators if they conduct an investigation, and you need to take note of everything that's said there because they can use this to turn around and sue you for something. Now, this doesn't mean that she was actually terminated for because we're talking about this employee, and we're giving comments about his behavior. That's something that can go, that the jury's going to decide in court later. And just to kind of piggyback on what Johnny was saying earlier, a lot of these claims are very tough to get to trial, we've never had to. In fact, I think every single employment discrimination or Title VII case we've always had it dismissed on summary judgment. It's tough to get a trial, but it's expensive to get to the point where you can get it dismissed on summary judgment. So keep that in mind when you are conducting investigations. They can use anything that they're said in there to, in another form, to prove discrimination. Another case it's a little bit older, but it's also a trend that we're seeing now, is that the delay that courts will allow between the time of the harassment and the time that the report is made about the harassment is getting longer and longer. It used to be that if you waited too long, then the employer received many protections. But the courts are allowing people employees who are allegedly discriminated against or harassed to wait longer and longer before they report that to their employer and still get the protections of Title VII. So encourage your employees to, if they ever feel like they're harassed or discriminated against, to report it as soon as possible. This is another trend that we're seeing. There's nothing in Utah right now, but New York City has recently proposed a bill that would ban credit checks from the hiring process. So we've got discrimination against people who have poor credit, and it's called the Stop Credit Discrimination Employment Act. And Mayor Bloomberg said that he would veto this if it makes it to his desk, but this movement is gaining traction. There's nothing in Utah right now. You can still use credit checks in the hiring process to weed out employees. But last year, 35 bills in 17 states addressed this issue. 8 states now limit the use of credit information in employment decisions. So this is a growing trend that you need to be aware of. Again, Utah hasn't addressed it yet, but just keep it on your radar. And another growing trend that we're seeing is that the unemployed are being discriminated against in employment decisions. And what do I mean by that? Well, the employment rate is high now. It's lower in Utah, but it's pretty high throughout the nation. And what employers are doing is they're saying, if you're unemployed, you don't need to apply. You only want people who have jobs applying for this particular position. And there are several. New Jersey was the first. New York's kind of coming around the corner here. And President Obama has initiated legislation as well to prevent any type of discrimination against unemployed. So that's another thing that, again, we're not seeing it in Utah, but it's something that you are probably going to see in the future, where you cannot discriminate against someone because they are unemployed in the hiring process. Let's see what else I want to touch. Okay, another thing that we're seeing, and it's also something that we're probably going to see more of, but the EEOC recently, just a few months ago, found that discrimination on the basis of gender identity, and this was against a transgender individual, has a viable claim under Title VII. It's not something that we've seen before. Now, I say just the EEOC, but don't underestimate the power of an EEOC decision with the federal courts. It doesn't have precedent. Plaintiff can't cite to a decision by the EEOC and say a court is bound. However, it's very influential. And in this case, it's called Macy v. Bureau of Alcohol, Tobacco, and Firearms. This is the first time that any court has found discrimination against a transgender individual constitutes sex discrimination in Title VII. So we're going to see this more and more. The take-home lesson is Companies cannot, should not consider gender in any form when making employment decisions. Don't even go there. Even if it's a transgender. Okay, so that's kind of, again, I have to do a little work before we got to the fun stuff, but that's kind of what we're seeing now as far as trends in Title VII employment law. So let's go to Title VII issues, and we're going to do a little test your knowledge today. Okay, hostile work environment. Let's just, who can tell me what constructive discharge is? There you go. Yeah. So constructive, perfect. Here, do you want to come up and take a prize? This is a putter cup. You probably don't want that, but you can keep on. I'm assuming this is mine. Perfect. So constructive discharge is when the employee was not actually terminated. They quit. But they quit because they felt there was a hostile work environment. So what is a hostile work environment? A hostile work environment is when objectively the situation at work was so bad that this employee felt they had no choice but to quit. So they weren't actually terminated. They were constructively terminated. And that's what we mean by constructive discharge. So the question is what is a hostile work environment? And we've been struggling with that for years in the court system. So let's get some real life examples. Coworker says, "I hate working with women. They belong at home." Okay. This is something that this employee experienced at work. Coworker said, "I hate working." Coworker said, "I hate working." What do you think? Do you think that's enough to constitute a hostile work environment? No, probably not. Probably not. Remember, it has to objectively be so bad that they have no choice but to quit. Supervisor says, "I hate working." You're getting closer, right? Yeah. You're getting closer, but I still don't think that that's going to be enough to be constitute a constructive discharge or a hostile work environment. Supervisor often berates an employee because of her race. Now, I'll just say this. I know attorneys that will sue and claim hostile work environment for the first one. Okay, that doesn't mean anything. The question is, what would an objective, reasonable person believe? A reasonable employee in the same situation. Supervisor often berates an employee because of her race. I think we're getting pretty close there to a hostile work environment. Although I've seen cases like this that the courts do not consider a hostile work environment. So, but I've seen this on the news. That's what makes it so tough. Supervisor daily berates an employee because of her race with no action by the company. Okay, and I think that's probably a hostile work environment. Okay. An employee would probably be justified in quitting at that point. These are all real life examples from real cases. Okay. So this is the case law, constructive discharge working. This is direct from case law. Working conditions so difficult that a reasonable person in the employee's position feels compelled to resign. That's the standard that they have to show a hostile work environment and constructive discharge. Essentially, plaintiff must show they have no other choice but to quit. The conditions must be objectively intolerable. The plaintiff's subjective views of the situation are irrelevant. So the fact that this particular employee has a particularly hard time with the subject matter does not matter. It has to be objectively intolerable in order to show a hostile work environment. And this is the 10th Circuit, which is our circuit here. Covers our state federal court. Okay. Vicarious liability. Who can tell me what vicarious liability is?
sorry. Just that the employers have to establish a policy that there is not race, sex, gender, correct? We have, that's how I read it.
Yeah, so, right. Essentially, employer can be held responsible for an employee's actions. So I don't know if you want.
Yeah, like the supervisor, so you have to have a policy, like if you have a supervisor, you're held responsible for their actions as it relates to
Right.
harassment, right?
Exactly. Vicarious liability. It's a concept that we often see in this law. Come up and get a prize if you want one. Okay. So even though the employer may not have a policy that discriminates against employees, they can be liable for the discriminatory actions of one of their employees. Employee must show an adverse employment action taken. This can be termination. This can be demotion. But it has to be one type of adverse employment action taken. Often the employer then will show some legitimate reason for the action taken. So I'll give you an example here. And then we had a situation where we had a female employee and a male supervisor. Okay. There were several sexual encounters between the female employee and her male supervisor. The supervisor gave one average performance review, gave undesirable duties, he denied certain shift requests, and threatened to fire her. She eventually quit, claiming that she was raped by the supervisor. Okay, this is a real case. So, what do you think? You can play a pretty good, strong case here for sexual harassment? On the face, it looks like she does, right? This case is actually dismissed on a motion for summary judgment. The problem was that there was no tangible employment action taken. One average performance review, undesirable duties, they're still part of her responsibilities, but they were part of responsibilities that nobody liked to do. So everyone had to take their turn doing these duties, but nobody liked to. And same with the shift requests. Everyone had to take their time doing these working these certain shifts, but nobody really liked it. And he threatened to fire her, but he didn't fire her. In fact, she just quit. So, despite the fact that he was her supervisor and that there were sexual encounters between the two, because there was no tangible employment action taken, the court dismissed her cause of action. And also she made a hostile work environment claim, but several of the encounters took place outside of work, so she didn't have a hostile work environment. And so it's now on appeal, but the district court made the right decision and dismissed this case on summary judgment motion. Again, she sued the employer, but not the supervisor. So this is a situation where she was trying to hold the employer vicariously liable for her supervisor's actions. And she could not because there was no tangible action taken. Any questions about that?
I wish it was that clear cut.
What's that?
I wish it was that clear cut as that, or that they actually make that decision, because that's not always.
It's not. It's not always clear cut. And that's why I say it's really tough for an employee as a plaintiff to get a trial in a Title VII discrimination case. It's tough because the employers are protected and they're protected under the law. The problem is it's not always clear cut. You can make a pretty colorful case, and if you've got a good attorney, you can twist the facts and you can make it look really good. And it takes a lot of time, a lot of depositions, and a lot of discovery, and a lot of litigation in order to get to the point where you can get the, convince the court to dismiss the motion for summary judgment or motion to dismiss. The key for employers is to not ever let it get to that point. So if the cliff, the edge of the cliff is right here, you don't want to be balancing on the edge of that cliff. You want to be walking as far away from the edge of the cliff as you can. And that's why we give you the hotline. Johnny talked about the hotline. Call us if you ever have a question about any type of Title VII issue, any type of discrimination issue. Just call us. It's free. We'll call you back within 24 hours if you don't reach us. You can call Kristen Van Orman. I know you probably all have her number. If not, I can give it to you. And you can call me, Jeremy Knight. Just call us if you ever have questions so we can avoid ever getting to the point where an employee feels like they have a hostile work environment claim, or they feel like they have a discrimination claim. Okay. Direct evidence of discrimination. One thing that an employee must do in a Title VII case is provide evidence of discrimination in order to make what we call a prima facie case. And that's just to get started. Of course, that's not to get to trial. That's just to get started. You have to provide evidence of discrimination. One way to do this is to provide direct evidence of discrimination. What is direct evidence of discrimination? Real life example. Female plaintiff accused her male supervisor of denying her job training opportunities because of her gender. Her supervisor, in an angry outburst over the plaintiff's performance of her duties, stated, "Bleep women, I hate having bleep women in the office." Okay. Does this comment constitute direct evidence of discrimination? Don't look at the answers because they're not. Well, remember, she just accused her male supervisor of denying her job training opportunities. That doesn't mean he did. And all we know that he did is right there in the second. This is what he said. This is his opinion. Is that direct evidence of discrimination? No. I don't know. I'm trying to give these away. Yes, there you go. I heard you say no. Here you go. Come up and ground. You're right. It's not. This is what the case law says. It's not direct evidence of discrimination. You took the golf off our faith. I thought it was a great idea. In contrast, statements of personal opinion, even when reflecting a personal bias, do not constitute direct evidence of discrimination. And this is direct from the 10th Circuit. But this does not mean there is no discrimination, obviously. There can be what we call indirect evidence of discrimination or circumstantial evidence of discrimination. So certainly if this person made a claim against her supervisor, this woman against her supervisor said, I think there's direct evidence of discrimination, the court would say no, it's just his personal bias, then she would immediately say, yeah, but look, he did this, he took this tangible job action against me, and he demoted me, and he put a nail in my place, and she could line up the different things that he had done to show circumstantial evidence of discrimination, but that's all indirect evidence of discrimination. It's not direct evidence of discrimination. And that's the reason it is so difficult to make these claims. It takes a lot of circumstantial evidence. Okay, again, let's talk a little bit about adverse employment action. To prevail on this race, gender discrimination claims, you have to provide evidence that the employee has to provide evidence that they were subjected to an adverse employment decision. This is done on a case-by-case basis. The key terminology when thinking about whether or not an adverse employment action has taken place is this significant change in employment status. Hiring, firing, failing to promote, reassignment with different responsibilities. They have to be significantly different responsibilities. Remember I talked to you about that prior case. This employee was reassigned from one position to another position, but the responsibilities were not significantly different. They were just a little bit less desirable. Has to be significantly different responsibility or cause a significant change in benefit. A mere inconvenience is not going to qualify. Okay, so what will suffice? What will suffice? Adverse employment action, what will suffice? That's the question that we are so often litigating when we get to the point of litigation. And again, the take-home message for this whole presentation is we don't even want to get to this point. Okay? That's why we have the hotline. If you have any questions, call us up. But we don't even want to get to this point. Stay away from it. But termination, but then withdrawing and reinstating with back pay. What do you think? Think that's an adverse employment action?
Yeah.
Probably. Probably yes. You know, you wouldn't think it is because they're reinstated with back pay. You know, no harm, no foul. But in Title VII context, courts have said that this is an adverse employment action. So if you're thinking of, again, take home message, if you're thinking of doing something, call us. We can talk it through, we can figure it out. This is Roberts v. Railroad. Again, roadway. Again, this is the 10th Circuit, which covers Utah. Poor performance reviews. What do you think? Probably. Again, let's go back to my test case. In this case, this employee who was claiming her supervisor was discriminating against her because of her gender. She received an average to poor performance review. We interviewed the supervisor and the supervisor. He looked at the performance review and said, I would call it average. It's not great. It's not terrible. I don't think it would affect her future job opportunities. So the court said it was an adverse employment action. Okay, increasing duties. What do you think? Maybe. It's always gray, I know. I know. This is why I have a job. It's a gray area. My example is and this is a real case, if an administrative assistant was asked to start cleaning the toilets twice a day, that's a real case. It's probably going to be an adverse employment action, okay? So, and it's probably going to constitute as retaliation as well. So, again, back to our vicarious liability example, my test case. Employee was asked to work longer shifts at a certain position, but was part of her regular duties. Increasing these duties was not an adverse job action. Failure to transfer. No. In fact, this one comes up quite often. If it's a lateral transfer, it is not an adverse job consequence. It cannot be considered sexual discrimination action. This is a instantiation. The court held that a female teacher denied transfer to a position with the same salary and benefits, that have the same duties, essentially, did not suffer an adverse employment action because of the purely lateral transfer. So you're probably safe there. Again, the take-home lesson, it's not always a clear answer. It's a case-by-case analysis. And you need to think about what you do and just be very cognizant of every move you make when these situations arise. Okay, so we're done. We've got some more time, and typically I have, oh, go
I
ahead.
have a question going back to performance evaluations. We were having a conversation at lunch.
What's that?
About performance evaluations and how it directly relates. Is it really a good thing to really have them? Because 99% of the time you get in a situation like this, the first thing the OLR asks you was another performance evaluation.
Yeah.
And you go to discipline. So in your opinion, do they help or are they hurting the evaluations depending? Because you have a disciplinary action that's showing this action that he's supposed to say, okay, what happened on the performance evaluation? And you know that supervisors, most of the time, not all, there are some that will actually do due diligence and address the situation there. We'll just put 3 and be average.
Yeah.
And we get caught in this thing. So is it a detriment?
No, don't change your, I think I understand the question, but don't, you have to give accurate performance evaluations.
But should we even have them if it's going to be a detriment?
I don't
think.
If the
Okay.
supervisors are not following the protocol and they're not really doing their performance evaluations like they should be, then it is a detriment to the county more so.
When you get in situations like this and because it is a situation currently that we are experiencing where they're going back to that all the time and yet, what do you do?
I would say no. I would say no. You still have to do them. I mean, you still have to evaluate your employees and make sure they're doing their jobs correct. Just because they're going to use everything they possibly. If an employee is dead set on suing for sexual discrimination or harassment or something like that, when there probably isn't any there, they're going to use every single possible avenue they can in order to.
Whether you have evaluations or not.
Right, right. So exactly. So you have to do it. You can't not do performance evaluations because you're afraid they're going to use them later in a sexual harassment suit. You can't not transfer an employee. You just need to. All I'm saying is think about all these things before doing this. If you have a situation where this employee has complained about their supervisor and harassment from the supervisor, you have to be especially cognizant of performance evaluations after that point, about transfers after that point, about certain things that you do because it could come back to bite. Okay, so what I'd like to do is I usually have embedded in here an episode of The Office, Relevant The Office, right? And but it's not on this computer, so I got this. Is there a trick to this? now it's time to have a little fun. We're going to go through, you can edit out the parts that are not appropriate. Painstakingly gone through this with the minutes to edit out, but I want to kind of, again, test your knowledge. It's not going to be hard to find all of the problems that happen, all the violations of Title VII that happen in the office, if you're familiar with it. So I'm going to stop it every once in a while and we'll talk about it. So I just thought I'd just start this thing. I didn't think this would be happening. Okay, so it's hard to hear, sorry. But who can see what kind of was happening there? It was subtle, but what do you think? See any problems with that interaction between D'Angelo and Pam?
So he was super positive with the guy, and it was short and hurt with her.
Yeah, he came in, he's talking to Daryl, and he was, chatting it up with him. When she came up, he was just kind of curt with her and obviously treating her very differently than he was treating Daryl. These actions, of course, this is just a clip from a TV show. That itself doesn't constitute discrimination or make a case for discrimination in federal court. It needs to happen over and over again. But it's something that we all often very an employer, with an employer. And more needs to occur, but it often does. And so if you see something like that, just that little teeny tip of the iceberg, that's when you need to take action and prevent it before it gets to the point where adverse job consequences take place. Or what's the other thing that can happen? Right? You said it. Over here. You get a good turn. Hostile work environment. So if there, he could be treating the women differently, not very nice to him. You saw him, he said, "What's up, dudes?" when he walked into his office, and he treated Pam like she wasn't hardly even there. If that happens enough where it gets objectively intolerable, then she can make a claim for hostile work environment and there can be constructive discharge. So let's continue on. Let's talk about what happened there. Who can point out some things? Some obvious things and some not so obvious things that happened in that clip. Probably violation of consent. Here's some laughing here.
I just love the inner circle thing. I think that's kind of, I think a lot of supervisors have to deal with that. Like at my work, I had a guy accuse me of a sisterhood, and I only had one other employee, but yeah.
Yeah, well, you hit it right there. It's the inner circle, right? The inner circle are all men in there in his office. He was talking about work. He was talking about going out and getting clients. Is it direct evidence of gender discrimination? No, probably not. But I guarantee that happens. An employee will and can make a disparate treatment claim based on gender. It's probably something that we see too much, and it's probably something that we're not fully aware of that we're doing, but it needs to be approached with care. But anyway, so the inner circle is circumstantial evidence of Title VII discrimination in violation of Title VII. It's evidence that of other similarly situated employees not in a protected class and receiving systematically better treatment. There's something else that happened there.